In this quick insight, we're going to cover construction contracts and specifically whether or not you need any review of them. And by review, I mean legal review. As always, these are for informational purposes only and not intended to be used as or substituted for actual legal advice from your attorney. We're going to cover three general types of contracts we see all the time. One's a commercial construction contract, another is residential construction, either for a new home build or an addition, remodel, and then finally the builder's addendum or a home warranty. These are attached to new home sales and a purchase and sale agreement. So commercial construction, typically you're going to see an AIA document. That's the Architects Institute of America. That's about 95% of commercial construction projects that we do. And there's a misconception that these forms are so dialed and baked that you really don't need to edit them. And that's, I don't want to say that couldn't be further from the truth because they're pretty good forms, but yeah, there's definitely a few things that you're going to want to tweak or have a look at if you're looking. And they vary widely based on the type of construction product we're talking about and the deal terms. But a few key areas that can get changed are architect versus owner controls. Virtually every part of the architectural, it's an architectural association. So it puts the architect in control of literally every part of the project. That may or may not be what the owner or contractor wants. So whether or not the architect versus the owner controls the project management and dispute resolution is one piece. Completion date with delay damages or not, sometimes specifying a liquidated daily delay damage amount can be included. Payment, application, or draw request terms. These are the time frames. If there's lenders involved, oftentimes they can't perform as quickly as the AIA docs specify. Cost savings allocations. This is something that is a percentage allocation between owner and contractor if there's a savings that can be found. And then of course, dispute resolution and insurance provisions. Oftentimes with insurance provisions, that's a whole other exhibit outlining specific terms that insurance advisors contribute information on. On residential construction agreements, we're seeing these more often as the price of construction rises. And so now instead of like a couple $100,000 for that remodel, you're talking $1 million, $1.5 million. So now the first thing that comes to mind here is that in the past you might have said, well, it's just a simple little project. We don't really need to spend any time with attorneys reviewing this. As the cost of construction has gone up and the cost of repairing defects has gone up, there's a need to take a quick look at this. And oftentimes these are going to be, if not always, on a builder's forms, and that can be great. Some builders have their stuff together and those forms are fine. Other builders have spent a lot of time and money on their forms 20 years ago, and a lot has changed. So specific issues that need to be looked at are change order language, whether those can be done in writing or mandated to be in writing and executed or not. Guaranteed maximum price or time and materials contracts, making sure that the form actually specifies that clearly. It's always amazing to us how often these come in and it's difficult to tell what the parties were intending. And then finally, the warranty language. There's been material changes in Washington case law on warranties, and we see a lot of agreements that are either not entirely correct in their application of the law or just deviate from what's commercially reasonable right now. Finally, we look at a lot of builders' addendums for, these are typically attached to a purchase and sale agreement for a new home. Here again, in the past, it was kind of like, oh, this is a big company, they're great, they'll be good for it, this will be just fine, and these were kind of non-negotiable because this is the company's form. Right now, there's a lot of townhome developers and other folks out there that are doing this, and they're perfectly open to review and suggestive change, particularly if their forms haven't been looked at in a while and they just sort of pulled something from ChatGPT or wherever. These are not all created equally, so there's different time frames for these home warranties. In an ideal world, they have some kind of express time frame and some express obligations of the builder to come and fix things. And then there's some basic tolerances. So look, you don't have a claim if the cracks in the drywall are bigger than 1/16 of an inch or something, because dirt shifts, drywall shifts, so there's going to be cracks. So those are a few of the things to look at if you're considering getting your construction contract reviewed. Have an attorney look at it, whether that's at Holmquist and Gardiner or elsewhere. Thank you for taking a look at this Holmquist and Gardiner Quick Insight. Thank you.